year, and it is in partnership being hosted by the Oregon Disabilities Commission, Disability Rights Oregon, and the Northwest ADA Center. And just to do some housekeeping, I think Carrie's pretty much already covered it, but we do have ASL, American Sign Language, and CART, which is the captioning. They will put the streaming link in the chat. So if you need the captioning, click on that link and it will give you the stream of it. We also have Spanish interpreters available. And as Carrie mentioned, there will be a link added in the chat for that, and also instructions on how to make sure that the rest of us are on the English speaking option in Zoom, so that we will be able to hear the interactions coming from our Spanish attendees. Also, next up is community agreements that we wanted to go over real quickly. So Rose, if you can throw those on the screen for us. All right, so just real quickly, access node is just to listen to your bodies. Feel free to move around, use your restroom, stretch, whatever you need as we attend this webinar today, and take your breaks as needed. Next slide, Rose. Also, just going over some rules for virtual meeting etiquette. Check if your name and pronouns are correct. Mute your microphone if you're not speaking. Try to remember to state your name before speaking. It helps with not only interpreters, but it helps with our captioning as well. Be present without distraction, and be respectful in the chat. This is not going to be, a place where we argue or debate or anything like that. We want chat conversations to be applicable to what the webinar is about. Next slide, Rose. Also, for the first time this year, those of you in the audience that has opportunities in your employment for continuing education credits, we are going to be offering that this year. And so if you will click that link and also use that QR code, it will walk you through the process of how to apply for those credits through your employment if you're eligible for that. Next up in our process is I'm going to introduce Jim Davis. He is the former Oregon Disabilities Commission Chair, and he would like to take a few minutes here to speak with you about the history of this event, the ADA celebration, and a little bit about the ADA overall. So, Jim.
Well, thank you so much, Joseph, and of course, you're just so amazing. I'm Jim Davis. I am a retired gerontologist, psychologist, professor who's been an advocate for seniors and people with disabilities for 50 plus years, since the 1970s. And it's always a pleasure to work with all of you and to be around all of you. I'm so excited about another great year of the ADA celebration and the webinar. I've been involved with this for decades, and I just am so excited, and it's so well planned, and there's so many wonderful topics that we'll be dealing with. I do want an opportunity to jump into the history a bit, but I do want to just thank for a moment. I want to thank Joseph Lowe and for his amazing work on this webinar and on the celebration, and for the ODC and their incredible work under the chair, Mark King, and then of course our sponsors, Disability Rights Oregon, is just our defenders out in the community, and then the ADA Center. They've really furthered education around ADA, and it's so critical that we all know about this. So I think we're blessed to have the partners that we are. And of course, the planning committee was an amazing group that put together an amazing event this year. So anyway, I think it's important that as we spend this month celebrating the Americans with Disabilities Act, that we kind of understand the history a bit. Americans with Disabilities Act is truly one of the greatest legislative achievements that we've seen in the disability community nationally. It's changed how society deals with uh, disabilities in everyday life. I mean, it's just the impact has been incredible. It's really one of the most comprehensive pieces of civil rights legislation that we've ever seen. It prohibits discrimination against people with disabilities. People with disabilities have an opportunity for greater participation in mainstream activities, to enjoy opportunities, career, business, family, recreation. And it really deals with both physical and emotional well-being levels and really what they're looking at and on the different titles. And it's really well worth people, having a read through the Americans with Disabilities Act. But it's all about equal access and the removal of barriers, particularly around buildings, public arenas, services, housing. Very, very key part of it. And then, of course, a lot of us work on within the disability community are issues that affect workers with disabilities, so that they don't face bias or discrimination, and that there are accommodations made for them so that they can reach to the levels that they deserve to reach in terms of career accomplishment. ADA looks at other things, healthcare in particular, access to services and confidentiality issues. The ADA looks at transportation, bus transportation, train transportation, other forms of transportation, pedestrian transportation, the ability to get off sidewalks and access things, access to disability parking and coverage for service animals. And then, of course, with the changes we've seen in technology, telecommunications has become a very important aspect of ADA issues. Um, Functionally, being able to function within that, and access technology, telecommunications, and particularly for the deaf and hard of hearing, I think those issues are particularly pronounced. So, there's a long ways to go towards undoing discrimination for people with disabilities. And we all know that we're still fighting, but we've made some tremendous strides with ADA, and we'll hopefully all of us will continue to fight for an end to bias and discrimination against people with disabilities. So thank you for having me. And Joseph, I'll put it back to you.
All right. Thank you, Jim. And yeah, I also noticed that I was so excited about getting this year started that I didn't even do my introduction. But I am Joseph Lowe. I work for Aged and People with Disabilities inside the Community Service and Supports Unit. And my role is that I'm the program analyst for the Disability Services Advisory Councils throughout the state, and also coordinator for the Oregon Disabilities Commission. So that's who I am. And again, thanks everybody for joining. And sorry, I missed my own introduction there. Next up, I want to introduce you to Mark King. He is the current Oregon Disabilities Commission chair, and he would like to just share a brief statement about ODC and the work that they do.
Hello. I would like to welcome everybody. And I'd like to say that the ODC mission is to secure economic, social, legal, and political justice for individuals with disabilities through system change to carry out this mission. The ODC identifies and hears the concerns of individuals with disabilities and using the information to prioritize public policy issues which should be addressed, um, publicizes the needs and concerns of individuals with disabilities as they relate to the full achievement of economic, social, legal, and political equality, uh, evaluates and advises the Department of Human Services, the governor, um, the legislative assembly, and appropriates state agency administrators on how public policy can be improved to meet the needs of individuals with disabilities. Thank you.
All right, thank you, Mark. And so next up, I wanted to introduce you to our partners. Melissa Roy Hart is representing Disability Rights Oregon, and John Doris is representing Northwest ADA Center. They're going to do brief introductions of their organization and then dive into introducing our panel for this week. So Melissa, you're first.
Thanks, Joseph. I'm Melissa Roy Hart. Hi, everyone. I'm Communications Director at Disability Rights Oregon. My pronouns are she, her. And let's see, I'm a Caucasian woman in my 50s with gray shoulder-length hair, and I'm wearing blue glasses today. I'm so excited to see the variety of people that are here in the chat and to be here again with everybody sponsoring this really important celebration of landmark disability rights law. So you were totally right when you said this is like the big one for everyone. So, just a little bit about us, Disability Rights Oregon. We're a nonprofit watchdog organization. We protect and defend the rights of people with disabilities in Oregon. We've been here since 1977. We are Oregon's protection and advocacy system. So if you don't know what that is, that's the federal government established the protection and advocacy system basically to watchdog the federal government and everyone, everywhere that our community lives. They knew they couldn't trust themselves, so they established the protection and advocacy system. There's an organization like us in each of the 50 states, all the territories, and then there's also a tribal one in the Four Corners. So we have a unique access authority in that we can go into the places where people with disabilities are, institutions, hospitals, schools, we can, jails, prisons, you name it, we can go and we can go unannounced and see what living conditions are really like. So we do a lot of litigation, a lot of resources and information for self-advocates, because it's definitely people with disabilities leading the movement. And we have a lot of different programs. We'll help you get back to work. And, we have a staff member, Susan Gall, speaking today. So I could tell you a whole lot more about us, but I'm not going to. I'm going to kick it over to John at Northwest ADA. Thanks, John.
You're welcome. Thank you. Good morning, everyone. Welcome to the presentation today. I'm John Doris. I'm the Assistant Director at the Northwest ADA Center. I'm Gen X with silver hair. I have a brownish beard. My background image is the Space Needle. I'm based in Seattle, and I'm wearing a red, white, and blue checkered shirt. And if you're lucky, or maybe if I'm unlucky, my cat might join us. She's black and white, and she might join me. She loves to join as soon as I start a presentation. So the Northwest ADA Center, we are Region 10 of the National ADA Network. So the ADA centers were created shortly after the Americans with Disabilities Act was passed, and they were originally designed to provide information to encourage voluntary compliance. And that essentially is what we still do. all of the regions have some variation in the programs and services that they provide, but all of us have the core mission of answering the hotline. The 800-949-4232 is a confidential technical assistance hotline where we answer calls from anyone that calls. So we'll get phone calls from people who may have had something happen at a coffee shop, or we may get a business from or a call from the business that says, well, somebody had a service animal and this is what happened. Is this what should have happened? Or we'll get a call from a library that said we're having a temporary event and we'd just like a little bit of guidance. So we're confidential. Our role is to be non-judgmental, just provide information dissemination. And the main way we do that is through the hotline. And we also provide trainings, educational trainings, and even on-site visits for assessments, accessibility assessments. So it's a wide variety of information that we provide as a neutral, sort of neutral third party and confidential. Sometimes people will think we're the ADA police. That's not what we do at all. And sometimes people think we might, help them in court, or there are lawyers that work for the ADA centers, and I'm an attorney, but I don't practice in Washington or in our region, Alaska, Idaho, Washington, and Oregon. So we will oftentimes give referrals to people who need advocates in that case. But again, we're just neutral, confidential source of information. Thank you. Joseph.
All right. Rose, if you can pop up the bios, and Melissa and John, I figure y'all could read the bios today. So y'all can split that up however you want. There's 6 people that you'll be introducing.
Sure, no problem. I'll read the first 3. Let's see, and I'm just reading what's on the screen, correct, Joseph?
Yes.
So first up, we've got Rebecca, and am I saying this correctly? Is it Ark? Rebecca Ark.
Arce.
Arce. Okay, Rebecca Arce. She, her, eye. Inclusion, Equity, and Accessibility Specialist at the Office of Higher Education Coordinating Commission. Rebecca is a woman with shoulder-length brown hair. She'll be wearing, well, in this photo, I'm not sure what she's wearing today. Rebecca has a master's degree in public policy from Oregon State University. She has used her education and lived experience in her public service career. Currently, she's an equity, inclusion, and accessibility specialist at the Office of Higher Education Coordinating Commission. She's a mother of 2 sons, the proud daughter of immigrants, and the first person in her family to go to college and receive a graduate degree. In her spare time, she enjoys fiber arts and playing in her garden. Next up is Olivia Foster, who's a student at Blue Mountain Community College. Olivia is a graduate of Hermiston High School with certifications as a phlebotomy technician, a clinical medical assistant, and in BLS CPR. While not currently employed due to medical reasons, her background includes customer service roles in a family restaurant and gas station. Her personal experience with chronic illnesses has given her unique insights into the healthcare system, fueling her interest in becoming an Ehlers-Danlos syndrome specialist. During high school, Olivia consistently achieved academic honors, including Gold Honor Roll in Colorado and multiple awards at Hermiston High School, such as Program of Study, Health Sciences, and several scholarships. She aims to be more involved in boards and councils to improve education for future students. And last for me is Andrew Caruana. Andrew was diagnosed with cerebral palsy at a young age and has been a lifelong advocate for people with disabilities, specifically working in higher education with collegiate populations, helping them navigate accommodations process and being a peer mentor. He also advocates more broadly for disability health and employment issues as the legislative advocacy coordinator for the Disability Health and Employment Coalition. Oh, that's great. He graduated from Willamette University with honors and a bachelor's degree in philosophy and disability studies, and is currently pursuing a master's in clinical mental health counseling and hoping to work with disabled and neurodivergent people.
I'll introduce Suzanne. Suzanne joined the Disability Rights Oregon team in July 2024 as a special education fellow, thanks to generous funding from the Council of Parent Attorneys and Advocates through the Oak Foundation and the Meyer Memorial Trust. A licensed attorney for over 20 years, Suzanne fights for children to get the free and appropriate public education that they are entitled to under the law. Her interest in this area began after placing her own children in Oregon public schools and witnessing systemic problems and their impacts on children and families. She is most proud of the successful outcome in the Ninth Circuit 2021 case SC versus Lincoln County School District, number 21-35242, which underscores the importance of ensuring IEPs are individualized, even when the student's needs are complex. Suzanne received her JD from Duquesne University in Pittsburgh, Pennsylvania, and her BA from Loyola University in Maryland. When she isn't working, she's on the hunt for the best coffee shops and restaurants in Portland. Oh, and Katie, she's the director. She's not going to be joining us today. She will be presenting at a later presentation. She's the director and disability rights attorney. And then me, I'm the assistant director. I relocated to Seattle from Orlando, where I primarily practiced corporate law and family mediation for nearly 15 years, and I remain an active member of the Florida Bar. I help clients navigate complicated federal and state laws to overcome their conflicts and obstacles so that parties could reach amicable solutions to move forward in life with renewed purpose. During my time in Orlando, I was an active volunteer with several organizations, including the Citizens Dispute and Family Law Mediation Program, the Florida Bar Grievance Mediation and Fee Arbitration Program, Middle District of Florida Bankruptcy Pro Se Clinic, and Cornerstone Hospice. I have a special passion for adaptive sports and inclusivity and continued my advocacy for inclusiveness in sports through participating in Seattle's LGBTQIA sports community. Looking forward to working with various community partners and helping the disabled community increase their access and enjoyment in various recreational sports and arts programs. I earned my Juris Doctorate at Florida State University College of Law. I went to Purdue University for undergrad, and both Central Michigan University and University of Houston for graduate school.
All right, thank you, thank you. And that on your screen now is also the announcement you saw at the very beginning in the chat, explaining the Spanish interpreter, but we'll go ahead and play that real quick for you as well, for anyone that has joined us since we started.
Si necesita interpretación en español, hay un icono en la parte inferior de su pantalla con un globo terráqueo que dice Interpretación, y se necesita escoger Spanish. Gracias.
All right. So now I will turn it over to our panel members today. Again, thank you all for being here and presenting. And we have your presentation on the screen. We will man the slides for you. Just let us know when you need it changed.
Great, thank you. This is Suzanne Gall talking, and I'm going to kind of give a broad overview of the special education law and how it relates to students with disabilities. There's a case that explains why these education and civil rights laws are so important in schools. Every day that a student is denied access to education, irreparable harm results. These kids can't get that time back. And what I use as a special education attorney to enforce these rights are three different laws: the IDEA, Section 504, and the ADA, along with its amendments. These three laws form the backbone of a student's educational rights. Next slide. Oh, next slide, sorry. Okay. When you hear the term special education, you're probably hearing about the IDEA as it pertains to students needing specialized instruction. And the IDEA guarantees students with disabilities the right to a free, appropriate, and I forgot the word, public education, otherwise referred to as FAPE. What is FAPE? It's an educational program that's reasonably calculated to enable a child to make progress appropriate in light of the child's unique circumstances. This law focuses on individual characteristics of the students. There's not one size fits all educational program. And how this process works is there's a team that includes the parent, school staff, and the student. And they look at the kid's strengths and weaknesses and where they are in that moment. And then the team sets achievable goals and they figure out how do you get from point A to point B through specially designed instruction, supports, accommodations, and services to get to the goal. All of this is memorialized in what's referred to as an individualized education plan, or an IEP. And this is, the IDEA is tied to federal funding, and the importance of that I'll get to in a second. Next slide. The second law that impacts students' educational rights is Section 504, and this is designed for students with disabilities who do not need specially designed instruction. These laws focus primarily on equal opportunity to participate. There is a FAPE component to Section 504. It's a little different than the IDEA, and its focus is, providing the equal access to education. What accommodations do you need to get the kid in the building, to get the kid in the classroom, and access the education to be able to learn? And this law is also tied to federal funding, which I'll get to in a minute. Next slide. Now, the ADA only applies, like I mentioned, when there is federal funding involved. And the ADA came in to extend the 504 protections to private entities. So in schools, it applies to public and private non-religious schools, daycares, and childcare facilities. The ADA provides equal opportunity for participation in an inclusive manner to the maximum extent appropriate in all aspects of a student's education: academic, social, PE, electives, extracurricular, transportation. And in addition, the ADA requires schools to ensure communication with students, parents, staff, and visitors is as effective as communications with people without disabilities. The ADA also requires schools to provide auxiliary aids and services. Next slide. To be eligible under the ADA, an individual must have a physical or mental impairment that substantially limits one or more major life activities. And major life activities, the list is exhaustive. It's, everything from seeing, hearing, eating, sleeping, moving, breathing, learning, concentrating, thinking. The list goes on. Where we see a lot of these issues is around whether there is a substantial limitation. Also, to trigger the ADA, you could have a history or record of an impairment or be perceived by others as having such an impairment. Sometimes there's issues around temporary impairments. For instance, someone who's going through some medical treatment, someone who has a mental disability that waxes and wanes. Those cases are decided on a case-by-case basis, depending on how long the impairment will last and the extent that it impacts a major life activity. Next slide. Now, after the ADA was passed, there were a couple of Supreme Court decisions that really narrowed the definition of disability. And that resulted in the passage of the ADA Amendment Act. This act tried to make it less burdensome to qualify for protections by expressly stating that the definition of disability shall be construed in favor of broad coverage. And this doesn't mean that there aren't barriers, but it helps frame the issues as intended. And this is important because without this broader framework to capture what a substantial limitation is, the student will not qualify for ADA protections. The ADA Amendment Act also went on to say that schools cannot prohibit consideration, or I'm sorry, that schools cannot consider any improvement that results from mitigating measures, except in the cases of eyeglasses and contact lenses. And I mentioned, next slide. I mentioned early on the connections with federal funding with Section 504 and the IDEA. And I think this highlights why the ADA is so important today, more so than maybe it was 6 or 7 months ago. For ADA rights to be triggered, there is no connection to federal funding. So from those of us who are dealing with the uncertainty of the funding stream with regard to advocating on behalf of people and students with disabilities, the ADA is a nice safeguard and catch-all that will help us continue this work regardless of what happens with the different funding streams. Next slide. And this is just a graphic to show the relationship between the various laws that protect students in schools. And as you can see, any student that in K through 12 that falls under the IDEA also falls within 504 and the ADA. Next slide. Now, the ADA doesn't expressly have a provision for FAPE, but the Office of Civil Rights has interpreted Title II to require school districts to provide FAPE to the same extent required under the 504 regulation. And this means that schools have to provide under the ADA regular or special education and related aids and services that are designed to meet individual education needs of students with disabilities as adequately as the needs of non-disabled students. Next slide. Now, what do ADA violations look like in schools? First of all, it's not just students that these impact besides staff and visitors. It also impacts students and their parents. There's more examples of how we see ADA violations in schools than we have time to discuss today, but a few examples are physically accessing programs or activities, accessing programming. Sometimes schools will require students to go through a more cumbersome, complicated evaluation process under the IDEA. And only after they don't meet that threshold, then they will consider a 504 or accommodations under the ADA. Another example is failing to ensure effective communication. And in addition to communication with students in classrooms, there's also the parent component. I see this a lot of times when schools are failing to provide accommodations to parents in their ability to meaningfully participate in educational decisions of their children. I see it in transportation. I see it in students being denied full days of school. And Disability Rights Oregon has been involved in litigation over the past few years. Maybe some of you have heard of it, JN versus the Oregon Department of Education. This is a class action that was filed to address the problem of the number of Oregon students that had shortened school days because medical needs were either too costly or disruptive. And in response to this lawsuit, the state passed Senate Bill 819 to put some checks around this practice. And because the state stepped in and put in these remedial measures, the district court just dismissed the suit outright without analyzing whether the problem was actually fixed. Well, yesterday, I'm happy to report the Ninth Circuit said not so fast. There isn't enough evidence to conclude that the shortened school day problem has been resolved. So the case is going back to the district court for consideration, and the fight continues. Next slide. We also see ADA violations by schools applying too high of a standard to protect students with disabilities. We also see it when schools are requiring parents to mitigate the impairment. before they'll do the evaluation. I see this with schools requiring kids to be on ADHD medication before they'll do the evaluation. We see lack of written procedural safeguards as posing problems, and there's no requirement for a written plan of these accommodations. And what I tell everyone that contacts me where there hasn't been something put in writing, I say get one. If it's not in writing, it didn't happen, it doesn't exist. If the school will not give you one, then you send the email. You memorialize any agreements that you've reached with the school, and then you put at the last line, please let me know by whatever date that you want to pick if my understanding is incorrect. So that'll give them a chance to clarify any problems, and you have it all memorialized. Next slide. Other obstacles that families and students face, fumbling school staff who just don't know how things work. It's not always maliciousness. Sometimes schools, when they're not accommodating, just don't know. I mentioned, forcing students to jump through extra hoops, like getting too comprehensive an evaluation, but sometimes it's something like making them go through response to intervention before accommodations will be considered. Students also sometimes face haphazard, informal accommodations, and schools claim that they're working. And what I see more often these days actually are requiring a student to fail a general education class before deciding that there is a substantial limitation that triggers ADA protections. And that leads me to the next slide of eligibility of ADA and the impact on twice exceptional students. Kids are smart, and a lot of times kids can access enough curriculum to pass. We see this a lot with twice exceptional students, and those are students that are gifted with a disability. And if schools are looking through the lens so narrowly, these students' ADA rights aren't triggered, and their educational needs are not being met as adequately as those of their non-disabled peers. And the students are never able to access the appropriate level of instruction. And the school's focus on grades fail to consider what went into getting the student that grade. For instance, maybe a student that doesn't have a disability, it'll take them a half an hour to do an assignment, whereas a student with a disability, it's taking them 3 hours at night. And this narrow lens means that these students escape the protections afforded by the ADA. So next slide. When a student or family is encountering some of these things that I've talked about, some of these problems, first course is document, document, document. Notify the need for accommodations. Let the school know about the struggles your student is having. Some families may keep journals or calendars for their own purposes. But what I always tell families is make sure you're sending emails to create a paper trail. I too often see some of these investigations being dismissed or complaints being unfounded because they say the school was not on notice of the problem. So make sure whatever you're doing for your own purposes is memorialized in an email to the school. And I know when you're dealing with some of these issues, tensions get high, people get angry, but no matter how angry you are, keep the tone of any of these emails as professional as possible. You never know who's going to be reading what you're writing to the school. It might be an investigator, a supervisor, or maybe a judge, and you want them to like you. Next slide. So if there is a violation, you have a couple of options. You can file a complaint with the school district. And hopefully this is after you've well documented what's been going on. And the internal complaint processes are usually found on the school district's website. And if you're not happy with the outcome of an internal investigation, then you can appeal it up to the Oregon Department of Education. Other options you have are filing complaints with either the U.S. Department of Education, Office of Civil Rights, or the U.S. Department of Justice, Disability Rights Division. And which avenue you choose kind of depends on the nature of the issue. If a more specific individual navigating within the system may better be fit for an OCR complaint versus a broader systemic complaint going with the DOJ. The last avenue that you have is filing a civil case in court yourself. Next slide. There are some bright spots that have evolved over the years since the ADA and 504. The Office of Civil Rights in 2012 issued a Dear Colleague letter that essentially said, keep the analysis simple when you're evaluating whether the disability qualifies under the ADA, and interpret disability broadly. In 2016, there was another Dear Colleague letter issued that pertains to students with ADHD, and it says that OCR will presume that if a student is diagnosed with ADHD, they are substantially limited in one or more major life areas unless there's evidence to the contrary. And the OCR also issued a resource guide for parents and educators in 2016. Next slide. And John, that's you.
Awesome. We're next going to talk about some enforcement actions that illustrate some of the issues that we just went through that Suzanne went over. So we'll discuss some different settlement agreements, and then at the end, I'll get into the Title II rule for digital accessibility. That's important. Those deadlines are looming, and there's often questions about that. So I'd like to start with program access. The Dunlap Community School District in Illinois 2021. This was just one elementary school, and one family encountered some problems. The outdoor rec area was not accessible. So they filed a complaint, and the Department of Justice investigated, and it was found, yeah, there was some issues here. For example, pea gravel and mulch, that's not a stable surface. So there are design guidelines for outdoor recreational areas and playgrounds and like a path of access. Those things are important. Well, I like to talk about the importance of the ADA whenever I do a presentation to discuss the importance of opportunity and integration. So opportunity to participate, but then also to be able to integrate with the rest of the community. So these program access issues for me, especially for outdoor rec, is that people with disabilities, when they're not able to participate in what is intended to be a recreational program, they're missing out on that integration with their peers. So this is an important case in that it's highlighting that it's not just the classroom, everything happening in the classroom in the building is very important, but also the ability to integrate, to participate in programs outside of the classroom. So this case is also a good example of just one person. Sometimes when I'm doing a presentation for different topics on the ADA, somebody will ask me, well, I'm just one person. Does it matter? Should I say something? Will it amount to anything if I make a complaint? Well, sure, just one person can make a difference. And I also like at the end, a settlement amount of $2,500 was provided. I also get a lot of questions when I'm doing presentations. Are these complaints just cash cows for people? Are they just trying to get rich by filing these complaints? No, these are not very large settlement amounts, if anything. So this is making a substantial improvement that would help a lot of children, a lot of people with disabilities. Next slide, please. And then Iowa City Community School District, Iowa in 2020. So it's still fairly recent. We had several families here that filed a DOJ complaint. There were school playgrounds at 12 different schools. They had been modified, altered recently, but the accessibility barriers weren't addressed. So the DOJ said, look, you need to make the modifications. This is important. So an important another aspect of DOJ settlement agreements. When the DOJ gets involved, they're going to stay involved. So all of these settlement agreements are going to have more requirements, more reporting requirements than if the entity had just addressed the issue from the beginning. So for us and for people with disabilities, this is good that they're going to be monitored and addressed and made sure there's going to be compliance down the road. But that's a lot of extra work for the entity if they had just looked at the issues and decided to take on those problems. Next slide, please. Lincoln Public Schools, this is 2024 in Nebraska, dealing with program access and effective communication. We see this across the country with a lot of school districts creating a school choice program. This can create complications. In here, Lincoln Public Schools, you had the creation of cluster schools. So part of the school choice program, you had students with hearing impairments who required ASL interpreters were just sort of clustered together and without consideration whether this was their neighborhood school. So that created problems. And then if they wanted to attend a high school, making a choice to attend a program that was interesting to them, then their parents would then have to incur those costs. So this was a problem. And the school system, after DOJ intervention, agreed that they needed to end this clustering system and then do more to provide effective communication. So the creation of an interpreter contingency plan. We see this oftentimes when, not just in schools, but across the board, where a business or an entity may not have a phone number or may not have an organization to contact to hire an ASL interpreter, or may not have a plan. What happens if the interpreter is not available? And so the aftermath of DOJ investigation into Lincoln Public Schools was that you really need to create one and put one in place, put something in place. Next slide, please. St. Vrain Valley School District in Colorado, 2022. This speaks to another common issue of trying to utilize somebody else, like a family member or a friend, as an interpreter. Here you had a parent who was deaf. Their child apparently was misbehaving in school. So the school district asked the parent to come and have a conversation with the principal and the school resource officer. So the child is having to interpret the conversations that were happening to the parent. And the parent asked for an ASL interpreter twice and was denied. Next slide, please. So clearly this is an issue. This is a problem. The school district agreed that they needed to be mindful of effective communication. So effective communication is a pretty broad term, but it essentially is touching on making sure that the substance content of that message communication is being effectively transmitted. So if you're talking about criminal charges and issues of discipline in school, that's pretty substantive. So an ASL interpreter is appropriate, and clearly you wouldn't want to put the onus on a child to provide that interpretation. So the school district agreed to create notice to the staff and professionals and reach out to make sure that interpreters were going to be available. And again, the complainant received $3,000. This wasn't an opportunity to get rich. This was not a large settlement amount for their troubles. Next slide, please. This is an interesting case, Spanish Schoolhouse LLC, because this is a Title III entity. And oftentimes people have this perception that the ADA is a little bit easier on a business. And because we do hold Title II entities like a city to a high standard serving the public. And we want to ensure that programs are accessible. But here we have a Title III business providing full-time, part-time Spanish language programs for preschool and kindergarten age children. So parents with a 2-year-old with epilepsy enrolled the child in school. They disclosed that the child had epilepsy. If there's ever a breakthrough seizure, this is the process. So they provided that documentation, provided the information from the doctor. They said, okay, this is the medication Diastat, and this is this is what you would do in the event the child has a seizure while at the school. And it was very clear instructions, and Diaset is meant to be used by the layperson. It's packaged in a way that it's easy to administer. And originally the parents wanted the child to be removed from the room and then brought back. But the school, the director said, no, we don't really want to do that as part of their objections. I want to just mention about Diaset. Again, it's a complicating issue for the school, even though it's sort of meant for lay people, was that it had to be administered rectally, which triggered a policy of needing additional staff. Because it's in a sensitive area, you have additional staff that monitors to make sure there's nothing happening for liability reasons. So there was a couple of reasons why they thought they didn't want to do this. Next slide, please. So the director was arguing after they disenrolled the child that this would be a fundamental alteration of their policies, that it would be, they didn't argue burdensome necessarily, even though they would have to have additional staff. And an interesting, they argue that it would just fundamental alteration in that now we have to monitor if a seizure is happening. And when I read through this, I thought, well, okay, I don't have toddlers, but if I was watching a group of children, I would probably be monitoring all of them all the time. I would, they'd probably be very active. So monitoring the health is probably something that's happening all the time. And that's how the DOJ responded. Next slide, please, because they ultimately said this isn't a fundamental alteration of your business. You need to provide a reasonable modification to your policies and practices, even though this is, even though your business is to provide this service, you can provide this, you can modify your policy of monitoring and administering the medication to a child who has a seizure. So that they've created a new policy, emergency anti-seizure medication administration policy and procedure. So this notice is given to all parents who may enroll their children with epilepsy or who may have a seizure to administer medication. So it's interesting. It might at first blush seem like a extra, more than you would expect the DOJ to require from a business, but they found that it wasn't overly burdensome. It wasn't unnecessarily for them to take that on. It was just an aspect of the business. Next slide, please. So this last part, I want to talk about the Title II entities requirements for digital accessibility. This deadline, this was issued in 2024, non-discrimination on the basis of disability, accessibility of web information and services of state and local government entities. So the deadline is coming up. Next slide, please. This rule mandates that state, local governments make their web content and mobile applications accessible to people with disabilities, and also covering any organization that contracts with state and local governments. So remember, Title II, entities, you can't contract out your responsibility. So if you're providing a service and then you decide you're not going to provide the service as a Title II entity, someone else is going to do it on your behalf, you're still obligated to comply with the ADA. And the same thing with this rule, you're responsible. So you'll see this with contracts with third parties, that they need to make sure that the products that they're delivering are accessible. So local governments make their websites, mobile apps accessible to all. And they adopted the WCAG 2.1 Level 2A standards. So if you go back, if you have an interest in settlement agreements and you go back in time and you look, lots of settlement agreements with the DOJ involving digital content were requiring WCAG 2.1. And many people argued before this rule was issued that there was always this responsibility for Title II entities, which would include schools and universities, to provide the information, to provide digital information, digital content, to make it accessible as just part of effective communication. But the rule is out and it gives a clear floor. So part of the argument was, well, what if we picked a standard that wasn't the one that we invested time and money? So now there's a clear floor. This is the minimum standard. Next slide, please. So web content and mobile apps. So if the Title II entity, whether it's the library or it's City Hall or the university, if there's information that's on their website that's important that you need to use as a user, then that needs to be accessible. Next slide, please. The deadlines, the smaller cities under 49,000 by April 2027, 50,000 or more compliance by April of 2026. So less than a year before this deadline. And then special district governments, April 2027. So where school districts are not special districts, they're connected to the city or county. So if it's a county school district, city school district, you go by that population. City police department, etc. You go by what it's tied to. For universities, you go by the state. So all the universities really need to be, most state universities need to be compliant 2026. The idea was the larger entities would have more resources, would have more access to professionals that could do that, and then give a little bit more time to the smaller entities. Next slide, please. So some exceptions, things that don't have to be made accessible, archived web content. These are things that were truly archived materials, things that you're meant to just store away, that they're not being updated in any way. It's just for maybe research, just put away in an archive, a true archive. Electronic documents, these are things that are not being used to apply for access or participate in Title II service programs or activities. So these documents, they just exist. They may be forms that were useful in the past, but if they're pre-rule and not necessary for anything, they don't have to be updated. And then third-party content that's not connected to the Title II entity, just stuff posted online that, when I think of this, like the library may post something on Facebook and say, oh, here's a contest. And then somebody else posts something in the comments that's completely unrelated. The entity doesn't have control over that. So that doesn't have to go back and update it. Next slide, please. Additional compliance exceptions, individualized password protected documents. If the electric company is sending me my bill and I can open it with my password, that's not part of the compliance. And then pre-rule social media posts, stuff that's stale, Halloween posts or Christmas posts or Ramadan posts from 5 years ago or something. Next slide, please. But even when the exception applies, the public entity must still make reasonable modifications. So a person with disability that wants to access archived materials, then the Title II entity needs to find a way to make sure that they can access that material and provide and accommodate a modification. Effective communication is always going to be important, always applies. If there's a way, if something is important that wants to be accessed and it's in the exception category, you still need to provide the effective communication if they need to access that material and communicate that. And then provide individuals with disabilities an equal opportunity to participate in or benefit from the services, programs, activities. Always remember opportunity, that's opportunity and integration, those are critical. Next slide, please. The next two slides are tools. If you might need them or if you might like them, these are just some accessibility tools University of Washington and Microsoft have supplied. Happy to share these with you after. I know a lot of people we receive calls from the hotline all the time or emails from professors or from Title II entities. Do you know of anything that would help me with XYZ? Even like a math professor reached out. Do you know of anything that might help me with my math course to make it more accessible? So this slide, next slide, please. These are just some more helpful tools: Canvas, PowerPoint, documents, creating videos. All of these are helpful resources that you might find useful in your own work in helping improve accessibility. Next slide, please.
This is Suzanne Gall talking again. Disability Rights Oregon is proud to about its 2025 revision to the special education guide. I've included a link in the materials. We have a Spanish version that is on its way very shortly, within the next month or so. Next slide.
Okay, this is Rebecca. I guess it's my turn. I'm actually going to focus more on our student panelists. I do want to just provide some information about the Higher Education Coordinating Commission. That's the HEC. So most people think that the HEC just serves like community colleges and universities, but we do an array of programming from apprenticeships, career certification, conservation corps, a lot of workforce development. I did put our link here on the slides. I can also put it in the chat if anyone wants to find out more about the HEC. As we said earlier, I'm one of two equity and inclusion and accessibility specialists. My whole team is actually here today. Rudy and Rebecca Lindstrom is our director, and Osvaldo Avila is my counterpart. Okay, so next slide, please. Suzanne did such a wonderful job laying out all of the laws for K through 12. In higher ed settings, community colleges and universities, it's a little bit different. There are only two laws that we rely on, and it's the ADA and FERPA, which is the Family Educational Rights and Privacy Act. That is important because it means that parents cannot engage with school staff, even at the community college level, if the student is a minor, unless there is a release signed. So if you are now in post-secondary education, the name of the game is self-advocacy. So all the tools, resources that Suzanne and John just provided are essential because you need to know some of this framework and background if you're going to start engaging and asking for services when you get to this level. So with that, I'm actually going to ask Olivia and Andrew some questions about their experience in post-secondary education and how they have had to do self-advocacy. So next slide, please. I put the questions also on the screen so it's easier for everyone to follow along. So we will just start here with question one. Olivia, this is for you. You're at Blue Mountain Community College, and if folks are not from Oregon, this is out in Eastern Oregon along the Washington-Oregon state line. So Olivia, can you please tell us what your transition was like to community college from your high school?
Um, Transitioning between the two was a little harder because I had moved from Colorado to Oregon my senior year. So I didn't have a lot of the hooks to like know people and what to do, where to go. And so I didn't know that for high school either. So then when I was transferring over to BMCC to start schooling, I didn't know about orientation or any of the stuff because I waited until the winter term to start for 2025. And so, yeah, it was eventful trying to get in because I had no information and the high school counselors didn't really know what either, like how to help prepare better. Yeah, I'm good.
Thank you, Olivia. And Andrew, you are in a different situation in graduate school. So can you tell us, expand a little bit on what your first transition was like to college and then on to graduate school?
Yeah, this is Andrew speaking. So just really quickly, going from high school into undergrad, I had an okay transition. In high school, I had originally an IEP, thought really, really hard to get a 504. And then after graduating high school, transitioning into college, because I had a 504, I got some additional outreach on behalf of the university just because they sort of knew with me coming in that I was going to have some access needs. But just one thing that I want to highlight is that for a lot of people in higher education, they're not necessarily coming in aware of 504 IEP unless they were already in that system. We see a lot of people in universities who are undiagnosed or like Suzanne mentioned, maybe didn't have access to those resources in public education because they sort of were doing well enough. And so in those instances, I think a lot of students do get missed just because there's not any initial outreach unless the university has some reason to know to do that. And so I think although it wasn't in my case, it does happen a lot, but more to my transition from undergraduate to graduate school, I found that to be enormously difficult for me just because it was I discovered that the different sort of like accommodation processes and policies were very different between my two institutions. And when I say different, I mean diametrically, entirely, completely different. The how you get accommodations was different. The documents required for the accommodations that I had at my previous institution were different. The appeals process was different. And so even just changing schools, there's so much expectations put on the student with the disability to really fight, to get things in the transition. And so it was a bit, it was a bit of a rough transition for me. But of course, I'm here now and making it work.
Yes, thank you. Okay, we'll go with Olivia first on this one. And can you please tell us what are some of your biggest successes so far on your post-secondary journey?
I have made it this far. That I haven't fully started really doing much except like this stuff, so I don't really have success for this yet. I haven't made it that far, I don't think.
This is Rebecca. I think you've made it further than most had hoped for you. And that's a big success, possibly to prove some people wrong.
That is true. Going from Colorado to Oregon, a lot of the counselors did not think I could make it that far, nor did they believe I was actually going to move. And so by junior year, I had all the classes. I came sophomore year summer to figure out what classes I need for medical classes to graduate. Did the classes that lined up with it junior year in Colorado and then moved to Oregon. So my senior year, I took the healthcare classes at the Hermiston High School. And so by the end of graduating, I had my pharmacy technician certification and my CPR and BLS certification. So in that aspect, yeah, I didn't think about that.
That's fantastic, Olivia. Thank you. What about you, Andrew? So far, what has been your biggest success?
I mean, I think, you can looking at the sort of, I guess, more obvious things. I'm very, very proud to have graduated undergrad with 2 degrees in honors. It was a lot of work, lot of work. But I think outside of just like piece of paper milestone achievements, I think some of my biggest successes that I've been most proud of are the ways that I've been able to work with other students and helping other students through the accommodations process, or work with and unfortunately more often than not fight with my institutions to get things done that need to get done, either getting door buttons put in place or having better policies and procedures in place. And I think that like a lot of those success moments where real change was able to happen are ones that stick out to me. And of course, the best part about them in my mind is that they're not just my successes, they're the successes of every single disabled student that I've had the genuine pleasure of working with and getting to advocate for a lot of these things. And just I wanted to just mention, Olivia, about your transition from high school into college, I had a similar experience of a lot of people questioning whether or not I could do it. And so I think, yes, very much just the fact that you're there and you're doing it and excelling at it is fantastic.
This is Rebecca again. Thank you, Andrew. Okay, I'm looking at the clock. So I think I'm going to get to question 5 here because this is important. Andrew, we'll go with you first. What advice would you give other students who have had a similar experience to your own? Maybe also advice for faculty and staff who work with students with disabilities?
Yeah, I think the advice that I would give to other students, and I'll just be blunt about it, is that in higher education, much like you said, much more so than in high school public education, they just sort of expect that you be your own advocate and that you know the things and that you are going in with the information. And with that in mind, the onus really does fall on you as the disabled person, to be able to be in the room, know what you're talking about, and be able to stand your ground. Because the unfortunate reality, I think, for a lot of students in higher education is that the system by its design really does not want to give a student accommodations unless it absolutely has to. And sometimes what that ends up looking like is having really difficult conversations with professors and with faculty and with accessibility departments, and being stern to make sure that you get the things that you need. And just in terms of advice, I would just encourage people to remember that there's absolutely nothing wrong with being your own advocate and with pushing for the things that you need, and that in doing so, you're not being a burden, you're being a good self-advocate. And then in terms of advice for faculty and staff who support or teach students with disabilities, it would really just be don't question a student's disability experience, and just, I mean, it's a balance, right, of not questioning and also just assuming that a student is going to be an expert on their own experience and what they need. Sometimes there can be kind of I think, curiosity with teachers, faculty, and staff about, they want to know more, they want to understand the disability, and so maybe they ask for questions or documents or proof that they don't necessarily need. So just the advice would just be trying to avoid that sort of line of questioning and mentality, and really just leaning on and trusting that the student who has the accommodations or who is asking for the accommodations knows themselves and knows their body. It's not the job of a professor to question, it's the job of a professor to support.
That was fantastic advice, Andrew. Thank you. Olivia, what about you? What advice do you have for other students or possibly staff and faculty?
So I've a lot of the same of what Andrew was saying, but don't go find somebody. If you don't know something, find somebody, and somebody will know something. Because the first term at BNCC, at least the first couple of months, I had no idea about any of the accommodations or how to access them. So that was a handful in and on itself. And that if for faculty, if you have a student who was in my situation, that if they don't know how to get there but they try to like communicate it or something, to try to find a middle ground to help and not belittle them for not having the accommodations or seeming like they are making excuses, to actually like communicate with the student. So yeah, because it was great.
Thank you so much, Olivia and Andrew. We'll turn it over to the audience. Maybe they have some questions, if not for Andrew and Olivia, maybe all of the panelists.
And this is Suzanne Gall. I'm wondering if I can jump in real quick, kind of to tie the two together. one of the K through 12 and upper education, I have conversations with families all of the time about making sure you're getting those supports in place as early as possible. When students are taking the SATs or the ACTs, the College Board, and I forget who governs the ACTs, but they're looking for a track record of relying on these supports. And if you don't have that well ahead of the testing dates, there's a chance that the College Board may deny that. And then for colleges, just making sure that you have that track record that you can show there were supports in place that were used. It'll make the arguments a little easier to make when you get up to the higher education level. The other thing I want to include that I did not include in my presentation was FACT Oregon. FACT Oregon is the Parent Training and Information Center in Oregon. Their website is factoregon.org. They are a phenomenal resource for all parents who are navigating the disability world in education as well as other aspects of life. They provide one-on-one supports. They have great tools on their website, and they also do trainings, some web trainings that are accessible on their website. So FACT Oregon, and there's an equivalent one in Washington that I believe is called PACER. But I just want to put a plug in for those two organizations to help you navigate this world.
This is Rebecca. Thank you, Suzanne. We do have one question for our students in the chat. And the question is, what could have been done before college or university to prepare you for transition to college or university as a disabled student? What could K-12 schools have done to support your transition better? Whichever one wants to take it first, go ahead.
This is Andrew speaking. I guess I can take it first. I think the hardest thing for me, because I felt like I had a lot of the supports that I needed in place just through having an IEP and being pretty comfortable in a self-advocacy space. But I think the thing that was hardest for me was among faculty, guidance counselors, and staff at my high school. And when I had shared my college plans with them, it wasn't so much that there was even a question of what should we do to prepare you to do this thing. It was more of a question of, can you do it? Is this something that, you're going to be able to do? I remember distinctly I had a conversation with a guidance counselor who had encouraged me to pick a school that would be more my speed. And so I think, in terms of what I would have liked to have been done beforehand is just, I think that there just is a very, under the surface, but pervasive ideology that college just isn't a place for people with disabilities that just fundamentally isn't true. And so I think just more awareness and more education around the fact that like higher education is a place where disabled people not only belong, but can flourish.
This is Rebecca. Olivia, did you want to chime in?
All I could really think about that I think would have helped more is having a 504 or an IEP in place, because I was in rural towns majority of K through 12, so I did not know about 504s, and once I got to a bigger school to know about 504s, they didn't want to do them. So I would try to make sure you have that, because it sounds kind of like it does help a little bit, but I did not know what a 504 was until I moved here.
This is Rebecca again. I thank you so much. I see, yeah, we're coming to time, so I'm going to turn it back over to our host.
All right. Well, thank you. That was an awesome presentation. Everybody was rock stars today for sure. Definitely informational. I appreciate every one of you for participating. And thank you everybody that showed up today. I just wanted to make the quick announcement that if you've not registered yet for next week, definitely do so. Next week's topic is going to be working towards equal access employment for people with disabilities. And the description of that is that the panelists will cover topics on how to navigate and understand employment options for people with disabilities. So definitely another great topic to be discussed next week. Thank y'all for your time. And yeah, if there's nothing else, I think we can go ahead and call it a day.
Excellent. Thank you, Joseph.
Thank you.
Thank you to the students for participating. Your stories were really inspirational and helpful. Have a great day.